Tell me when you see me. Oh, okay. We're just going to do a little test here for lighting and sound, and glad you're here. Think we're good? You can see me? Okay. Welcome, everybody. I'm Paul Rabelais, third consecutive YouTube live presentation. Topic of this one today is how to keep your heirs and your estate out of probate. And got a lot to cover. This one may be a little shorter than the other ones that I've done over the last couple of days. If you missed the last couple of YouTube live presentations, you can go on my YouTube channel called Rabelais Estate Planning LLC, and they're right there. And so you can check those out. And then we got 3 more coming over the next 3 days. Some good topics. If you want to find out what those are, I post them on our channel's community tab, so feel free to check that out and then just show up live and we will rock and roll. Okay, so one of the first things that people often say when they come into my office and I ask them, what do you want to talk about or what do you want to make sure we address? I'd say about half the people, first words out of their mouth are, I want to avoid probate. Some of them, they don't know what probate is. Some of them do. Some of them have been through it, but they just think or know that they want to avoid it. And so really we're going to get in today what's involved in that process of avoiding probate, what it is, why people do it, what are the technical aspects of it, how do you do it, how do you maintain it. So that's what we're going to go through today. All right. So first, let's go over why people want to avoid probate. I'd say it's a little bit more of a maybe controversial thing. Maybe that's too strong a word. Here in my state of Louisiana, seems to be a lot of lawyers are adamant about, hey, look, you don't need to avoid probate. Just write a will. The probate won't be that bad for your heirs. And so there's a school of attorneys that kind of preach that. There's a few attorneys out there saying, you got to have a trust. And then there's the in-between. Good morning, Shetty. Thanks for the comments. Love to see the chat. Love to see the thumbs up, likes. And so keep them coming. Try to keep your chat positive, constructive. If you have something to add, feel free. Grammar, if it's halfway, great. That's awesome. So keep it coming. All right. So, and then, but my goal here, educate, inform, not try to push you to one thing over another, but get you to where you can make some really educated decisions. Because really this process of working your whole lifetime, and busting your tail to try to accumulate something, and then hoping that you can leave some type of legacy inheritance to your loved ones who may be in the same or next generation, you got to get it right. And so it's worth taking the time to educate yourself, watching things like this, reading, researching, so that those decisions that you make are the right decisions. Because in the area of estate planning, if you mess up, boy, it could really, at worst, cause your family to lose money, or at best, cause your family to lose money. At worst, really destroy the relationships of the people that are closest to you. So important that you get it right. All right, let's jump in. Why do people say they want to avoid probate? And there's probably several reasons. One, it's they've experienced something bad with probate. Their mother died, their father died, a relative died, and they were stuck dealing with lawyers and courts and executors who didn't do what they were supposed to do. And either money was lost, additional taxes were paid, courts, delays, harassment, uncertainty, all of that led to stress. And so some people have had bad experiences with probate. And I'm going to define really what probate here is in a second for really the beginners. Others have read. There's in estate planning, it's kind of the first topic that you see in estate planning. You ought to get your estate in order so you can accomplish these 5 things. Often at the top of the list is avoid probate. So people read, you're supposed to avoid probate. So they come to talk to the lawyer. They say they want to avoid probate. And then just others have this mentality of, I don't want the government in my business when I die. I don't want my family to have to deal with courts and lawyers and the government when I die. If there's something that I can do to avoid that, I sure do want to avoid it, because I don't really trust the government's processes and procedures to make things easy for my family. So I want to avoid that. So there's a number of reasons why people express to me that they want to avoid probate. But let me back up for a second and talk about what probate is. And first, let me talk about some terminology. In my state, it's often called succession. In other states, it's called probate. If I say those two words, I mean the same things. It's when someone dies with something in their name, and I've got to clarify what something means in a minute. But in general, when somebody dies with something in their name, that asset, let's call it a piece of real estate, or let's call it an ownership interest in a business, or a share or shares of stock, then those assets are what I call frozen. And it's just the way it is, the way it has been for generations. Whoever created this, it has blossomed, but the system is such that our government or our judicial system has been put in control of making sure that when somebody dies, their stuff gets handled the right way and then ultimately dispersed to the right people. So our government, our judicial system oversees that, and that's where people start not liking that component. And quite frankly, I can't blame them. All right. So when somebody dies, and some people mistakenly believe, hey, if I have a will, the probate's avoided. Nothing further from the truth. What a will does is a will names your executor, and that's whose job it is to hire the lawyers to guide the family through the court process. And your will is going to tell a judge who to make sure that the remaining assets get dispersed to at the conclusion of that court proceeding. But the will doesn't eliminate the probate. Some people incorrectly believe that it does. All right. Keep coming with your chat, even if it's a hi. It lets me know you're there. And I know we got a few people on, and I know that the majority of the people viewing this will be after in the recording on the YouTube. But we are live here. So if you got anything, bring it on. All right. So how do people avoid their survivors, whether it's their spouse or their children or other loved ones? How do they avoid their family having to go through that? Because the general process, if dad has a will, let's say dad's single, let's keep it simple. Dad has a will. It says, I leave my estate to my 3 children equally, and I name my oldest son as the executor of my will. Dad dies. He has a house. He has some bank accounts. He has some investments. He has some vehicle, all the normal stuff. Well, all that stuff's going to be frozen. And now the kids are going to have to come to lawyers, myself. This is the probate process. And then we've got to file all these pleadings to get the son confirmed as the executor, to get the judge to rule that dad had a valid will. And then son's got to open up estate accounts at financial institutions and pool all of the money under the court supervision into these estate accounts. Then lawyers have to prepare more accountings and pleadings and inventories. And then we've got to get all the heirs to sign off on all of that. Then we've got to file all that stuff back at the courthouse, and then wait on a judge to sign the appropriate court orders ordering that assets be transferred from the estate to the heirs in the proper proportions or amounts. And then we get those court orders to the financial institutions. Their lawyers review them, and their lawyers approve the disbursements. All that, that was a short version of a process that could take a very long time. And oh, by the way, with the coronavirus and stuff shut down, probate just ain't happening. We are handling several scenarios. I kind of feel sorry for a family. The father died maybe a couple of months, must have been early January where the father died. And by the time the kids, came to see me to start getting the estate settled and start the probate, it was late February. And so by the time we started filing and opening up some of the court stuff, it was early March. And then coronavirus hit, courthouses shut down, judges stopped working. There are out in America out there are many, many, many families who have no access to the family's funds or the parents' funds because they're frozen and judges are not signing orders. And I don't have a thorough understanding of what's going on at courthouses these days, but it appears that the only things being handled are these emergency, issues at courthouses, like criminal matters, like temporary restraining orders. But the probate stuff it ain't getting done. And so families are in limbo. And I got to feel like what would have taken maybe 6 months to get done before all of this mess is now going to take maybe a year to a year and a half, maybe more, to get through the court process. And so you can now magnify when people say, boy, probate takes a long time, or it's stressful, or there's all these delays, or we're waiting on stuff from the courthouse. That stuff is just exponentially growing. Who would have thought that a virus would virtually shut down our judicial system? But at least in the probate area, it has, and it's magnified the problems and what people don't like about probate. So now I want to go into let's jump right in 11 minutes into it. What are the typical steps that a person takes when they want to make the whole estate settlement process easy for their family? They want to keep their family out of all the court and attorney involvement. What do you do? Okay, and I wish it were the same for everybody, but it's different for everybody. But I'm going to, answer that question to the best I can. And hello to you from Arkansas. Wow, it's fantastic that people are watching from Arkansas and from New York. Stay safe, T. Mitch. All right, stay safe, everybody. Okay, so here's the steps to just making your estate settlement simple for everyone. All right, number one. I'm saying you got to see a lawyer. You don't have to see a lawyer. There's the LegalZoom. There's the other stuff out there. I don't really like it because there's just so many moving parts. It varies from state to state. Every family situation is unique. Let's just say you got to talk to a lawyer. And one of the first things that is discussed is once a decision has been made, let's see if we can keep this stuff out of the courts. Then there's a discussion about setting up what is often called as a revocable living trust, living revocable trust, living trust, RLT, whatever you want to call it. Some discussion about setting up, I'll call it a revocable living trust. From here on out, I'll just call it the living trust. And why would there be a discussion about setting up a trust if you're wanting to avoid probate? In my older example, Dad died. He had a house. He had accounts in his name. They were frozen when he died. Things in a trust don't get frozen. Dad could set up a trust and customize his trust in the way that's right for his family. When he died, he could have designated one of his children to be the trustee of his trust. And in his trust, he would have designated who's entitled to receive the trust assets when Dad dies. Perhaps he would have said his children. And that would keep things out of the court system, because the courts and the government only need and want to oversee the distribution of assets that are in your name when you die. So by creating a trust and transferring title of assets to a trust while you're alive, you're keeping those assets out of the court, judicial, attorney involvement system. Okay. By the way, thanks for all the thumbs up. Got 10 people on the thing and 8 people have already given the thumbs up. That's fantastic. If we get 2 more, that'd be great. All right. So step 1 is talk to an attorney about arranging your affairs to stay out of probate. And that discussion will start by talking about the terms of your living trust. So, trust can be several pages long to dozens of pages of long, but essentially, what are the things that are customized when you set up a trust? One is who's going to be the trustee when you can't be the trustee. Maybe you get incapacitated, maybe you die, or not maybe you die, you die. who's going to be in charge of the trust at that time? Most people pick a family member, perhaps even a ultimate beneficiary of that trust, to be the trustee in charge of selling the home, going to the financial institutions, dispersing the funds to the beneficiaries in accordance with number two, who are the, I'll call it the death beneficiaries of your trust. Who's entitled to receive your trust assets when you pass away? Could be the children equally, could be different people in different percentages, could be a specific amount to grandchildren with the rest to the children equally, could be your family home to this child, the rest to these children equally. There's really no restriction on how you can provide for the distribution of trust assets upon your death. There are some restrictions, of course, but as long as you do it within the rules, everything's fine. There'll be a decision typically about whether those beneficiaries upon your death are entitled to receive the assets, what I'll call outright versus in trust. If you leave assets out of your trust to a beneficiary outright, you're saying they can have it as soon as I die in a lump sum and then do whatever they want to with it. It's not my problem anymore. So that beneficiary share might be $250,000. They get their $250,000. They do what they want to with it. They go their merry way. If they blow it, they blow it. For many people who set up trusts, that's the way they go. Others will say, you know what, for some reason, I don't want this beneficiary to get the assets in a lump sum. I want it doled out to them over their lifetime, used for certain things, and then maybe at a later date, perhaps when they're more mature, then they can have what's left. So that scenario might be appropriate if you have beneficiaries who are young, or if they're minors, or if they are not responsible enough to handle a lump sum of money because they're going to blow it, or they're getting certain government benefits that require that they have less than $2,000 in their name. So you want to put things perhaps in a special needs trust so that it preserves their government benefits. Some people say, I want my assets for my child to go into a trust because I don't want it to be commingled with other assets that my child may have with their spouse, because if my child gets divorced, I don't want my in-law to get half of my child's inheritance. So there could be, I just reeled off 4 or 5 reasons why people provide in their living trust that when they die, assets will continue for the benefit of a beneficiary in trust for some period of time after that. All right. Thanks, Team Mitch. Probate is a big hassle and expense. Those are typically the 2 biggest complaints. Hassle, expense, delay. That's what we hear from everybody. Not everybody, but most people. And then the primary reason we have a trust is to make it simple to execute after the death of the first spouse. Another great reason, Tom. I'm glad you brought it up. I probably would not have if you didn't mention it. So I don't mean to be offensive to a certain gender, but a lot of husbands and wives come in, and the husbands, most of them, it doesn't always happen this way, as you know, obviously, but most of the husbands think they're going to die first. Most of them. Some of the wives do, but when I ask them, which one, who wants to volunteer to die first? I make a little joke of it because I like to run through the scenarios. Most of the husbands say, I'm going to go first because I've got this health issue. I'm older. I'm male. Males don't live as long as females. So, and traditionally, many of the husbands out there have been kind of the provider. And so they're really worried. They've handled the money. They've handled the investments. They handled the retirement account while they were working. When they retired, they handled the retirement account and the rollover and they're the one in charge of overseeing everything. And maybe, the wife is interested, but he's just done it. And it could be vice versa either way. But I just see a lot of the males kind of telling me, I want to make sure my wife is okay if I pass away. She's going to be dealing with a lot of difficulties with, having to do all of this stuff after I'm gone. She's a strong woman. She can handle it. But I just don't want her to have to go through any unnecessary burden. I certainly don't want any of our investment accounts frozen. I want her to have immediate access. I want to make things as easy as I can on my surviving spouse. And the wife may say the same thing. You know, she might say, if I pass away, I don't want my husband to have to go through all that. He's going to have enough to deal with. So, one of the reasons many couples establish living trusts, it's not even so much to make it easier for the kids, but it's just as important to them, if not more important, to make things easier for their spouse. Great point, Tom. I don't know if that's what you were getting at, but I'm glad you mentioned it. All right. So going back to somebody, let's call her Sandra. No, because Sandra's got to die for all this to work. Let's make somebody else's name up. Let's see. I'm looking at Fox News, and I see Lieutenant Governor from Texas. His name's Dan. Sorry, Dan, but I'm going to knock you off. Dan wants keep his kids out of probate, and so Dan is talks about setting up his trust. He wants, for some reason, he wants, let's say 50%. No, let's say he wants 20% of his estate to be divided among his 4 grandchildren when he dies. And he wants the other 80% of his estate when he dies to be divided equally among his 2 children. He has 2 children, and each of those children have 2 children. And so we talk about that, and Dan wants to name both of his children as the co-trustees to handle all of this when he dies. So we set up, we talk about that. I ask him the questions. He makes the decisions. We prepare the trust instrument, might be called the Dan Living Trust, with Dan as trustee and with child A and child B as successor co-trustees. Beneficiaries are each grandchild gets 5%, each child gets 40% when dad dies. And of course, there's lots more trust instrument provisions, but those are the ones that were most important to Dan. Okay, so that's setting up the trust. He comes in and signs his trust. His trust is established. But Dan's work is not done. Dan has more things to do, because to make a trust work, and this is one of the things that I talked about in yesterday's YouTube Live presentation about, it was titled, If You Have a Living Trust, Watch This. Probably the number one, I don't know if mistake is the right word, that people make when they set up a living trust with the intent of avoiding probate, is that they not only have to establish their living trust, they have to retitle the assets that are in their name into their trust. Not all of them, and I'm going to go through those in a minute. But it is very important that the trust get what's called funded. Some people say, what is funded? What does funding a trust mean? And funding a trust means transferring the title of assets that you own from your name to the trust. So let me give an example. Dan has a house, and it's in Dan's name. And Dan sets up a trust, and he doesn't want, he wants his kids to be able to, sell the house after he dies without any difficulty. So he wants it to be in his trust. And so when Dan signs his trust, he also signs additional paperwork that the estate lawyer probably prepared that transfers the house from Dan to Dan as trustee of the Dan Living Trust. And so that's how the real estate gets transferred. Dan may have some investments at Schwab or Fidelity or Vanguard or Ameritrade, Edward Jones, any brokerage firm. Well, as part of making sure those investment accounts don't get frozen when Dan dies, it's important for Dan to go retitle those investment accounts. If he has an advisor, he'll just call his advisor and say, hey, I set up a trust. I need to retitle my investment accounts. The investment advisor will say, no problem. I do it all the time. Here's what we need to do. Might have to sign an electronic form, or might even have to sign a signature on something to get that done. So that's how that gets done. All right. Now, when we talk about funding the trust, so Dan has set up his trust. Now he needs to retitle the assets. I'm going to look at it as 3 different categories of assets. Some never get transferred to trusts. Some sometimes get transferred to trusts, and some always get transferred to trust. So this is where people get a little bit confused. Let's look at and there's an exception to every rule, but let's look at what of the assets of yours would always get transferred to a trust if you had a trust and you wanted to keep your family out of the court process? Well, that's typically your real estate and your investments. Those are the two big ones. And by investments, I'm going to break it down. I'm talking about the kind of traditional individual or joint brokerage account, not retirement account. I'm gonna get to that in a minute, but you've been investing and purchasing investments, acquiring investments, whether you inherited them or purchased them in a brokerage account with what I'll call after-tax money. Those are probate assets that would go through probate if they were in your name when you die, and we want to get those retitled in the name of your trust. So those are always the real estate, the family home that's always transferred, and then other real estate that you own, as well as, business interests, LLCs, if you own, privately held company, all that stuff, that's all also part of the, always goes in your trust. Then never or almost never goes in your trust assets are the things like your 401k, if you have a 401k with your employer, your IRA, your traditional and your Roth IRA. 401k, IRA, traditional IRA, Roth IRA, those have to be in an individual's name. They can't even be in a joint name with your spouse. They have to be owned by an individual. Yes, you can name a trust as the beneficiary, but we're not talking about that right now. We're just talking about how you own 401k assets, IRA assets, perhaps a traditional IRA or a Roth IRA. Those are required to be in an individual's name. Those never get transferred to some type of avoid probate living trust. They don't need to if the goal is to avoid probate, because by their nature, they avoid probate anyway, because you name designated beneficiaries of those assets. So if Dan has an IRA and he names his two kids as 50-50 beneficiaries, and he has $500,000 in his IRA when he dies, then each child, as soon as the children give the financial institution after Dan dies a copy of the death certificate, and as soon as the children establish their inherited IRA accounts at the financial institution, then the money will be moved 50% to child A's inherited IRA, 50% to child B's inherited IRA account. And if that was a traditional IRA, the kids have 10 years within which they must take out those distributions and pay income tax on them under the new Secure Act, which is another topic. Okay, so the never transfer to your trust, IRA, 401k, annuities are often not transferred to a trust. Those also have beneficiaries. Life insurance, often not transferred to a trust because they also have beneficiaries. Again, you can name a trust as a beneficiary. So if you are a life insurance owner and you have two children who are 2 years old and 4 years old, you never should just name them as your beneficiaries, because it's a legal courthouse guardianship nightmare when minors inherit things in their name. So if you are that parent with life insurance, you want to make sure you set up and name a trust with the children as the beneficiaries of that trust as the beneficiary of your life insurance. Okay. So keep going here. And then the sometimes get transferred to your trust. This could vary on state law, on things like banking rules in your state, things like Office of Motor Vehicle rules in your state. So you need to talk to your bank, your lawyer about whether these things should go in your trust. But we'll talk typically bank accounts, vehicles, and then the non-titled personal effects, all the stuff that you have in the home. This beautiful painting that you see behind me, that was expensive, but I think secretly maybe a preschool person might have made it. Shh, don't tell anybody I said that. Okay. So we've got the always goes in your trust, the real estate and the investments. The never goes in your trust, IRA, 401k, most of the time not life insurance and annuities. And then the sometimes goes in your trust. Check with the person who helps you establish your trust. bank accounts, personal effects, and vehicles. And then there's even other assets, and you'll just, every class of assets has its own rules. So there's things like timeshares, United States savings bonds, RVs, there's boats, guns, there's all kinds of different rules. And so it can vary from state to state. All right, so good question there. Do you need a separate trust for husband and wife, or can you have one for both? So I see from your prior comment where you said, hi from New York, you're in New York. Well, you can do it either way. It's really common in my state and the other 8 or 9 community property states, really common for married couples to establish their joint trust. Married couples can't have joint wills. So wills have to be made individually. The husband has his will, the wife has her will. But when it comes to trust, a husband and wife together can make a joint trust. And I'd say that's most common even in states like New York. Husband and wife will prepare a joint trust. We'll see individual trusts, one for the husband, one for the wife. Perhaps maybe they each have children from prior relationships or prior marriages, and they each have different beneficiaries. We'll even do that here in Louisiana sometimes, where it's more appropriate for each spouse to have their own trust. But a married couple can have a joint trust. Again, one of those state issues. But I think couples like the idea of having that joint trust, unless there's some reason not to. Kind of like the coronavirus guidelines: stay at home unless you can't stay at home unless you need something, or get all your groceries so you don't have to go to the grocery store unless you have to go to the grocery store. So just crazy rules like that. Saw something yesterday that was kind of funny about that. All right. So we're 3-step process. I'm going to talk about step 1, create your trust. Step 2, fund your trust. And then step 3, maintain your trust. Create, fund, and maintain. CFM. Maintain your trust is, you may be 55 years old, 65 years old when you establish your trust and initially fund your trust, but life changes and people go on with their lives. They acquire new assets. Sometimes family circumstances change. They dispose of things. And so their trust needs to be maintained. So let's say a common scenario, Dan decides to, after he sets up his trust and puts his house in his trust, he decides to sell his trust because he wants to downsize. So he's the trustee of his trust. No problems there. He sells it. The check is payable to his trust. He goes and deposits that check into a trust account that either previously existed, or he sets it up when he gets that check, and then he uses those funds to purchase his new home, titles that home in the name of his trust when he buys it, doesn't even really have to tell the lawyer about it because the lawyer doesn't maintain in the trust instrument a listing of all of the trust assets. Dan just really needs to make sure that as he acquires new assets over the rest of his lifetime, he acquires the real estate or opens the investment account in the name of his trust. So it's titled in his trust when he dies. It's titled in his name. It's not titled in his name where it would have to go through the courts to be transferred to his heirs. Okay. Looking at the chat box real quick. Do we have to have the will and trust planning for both husband and wife? I'm not sure what you're getting at there, but typically when somebody's married, they come in and they do this for the married couple. And yes, they have their trust. And yes, we also prepare a will for them in the customary living trust, avoid probate, estate planning, legal program. There is a will or last will and testament component to that. It's typically referred to as a pour over will. Let's go back to Dan, who set up his trust, has his 3 kids, retitled everything in his trust when he set it up, but then 10 years later, he went to Charles Schwab and he opened a new investment account in his name, and then he dies 3 years later. All of those trust assets that are in his trust, they're going to go to the kids easily, kids and grandkids. But Dan, come on. He forgot that when he set up his investment account 10 years after setting up his trust, even though we told Dan and gave him instructions, Dan opened that new investment account up in his name. So he dies, that account is frozen, but Dan had a will, and his will said, if I have anything in my name when I die, I leave it to my trust, but we'll have to go through the probate process to get that account transferred from Dan's name to his trust, so his successor trustee then can do what he needs to do, and disperse the assets, sell the investments if that's appropriate, disperse the trust assets to the kids and grandkids, whatever Dan said in his trust. So virtually every time somebody has a living trust, they also have a will. The goal is to never have to use that will, because wills are only used when someone dies with something when something is in their name, and we've got to go through the court process to get it transferred. So people have a will. The goal is to not use it. Really, the trust replaces the will. The trust governs all of the assets that are titled in the name of the trust. And then, of course, when someone dies, they often have beneficiary designation items that go to the designated beneficiaries outside of probate. Okay, and then yes, I didn't even mention the advanced medical directive. Yes, all that's part of a comprehensive estate planning program. Medical directive, or sometimes people call it healthcare power of attorney, medical power of attorney, financial power of attorney. And so those are ancillary and additional items that need to be addressed as part of an overall kind of comprehensive estate planning legal program, so that not only it goes smooth when you die, but if you ever become incapacitated, you'll make it easy for certain family members to be able to talk to your doctors, gain access to your medical records, go to the doctor with you, blah, blah, blah. All right. And so that'll be a topic for another YouTube Live presentation. And then sum it up here, Dan dies. If everything was created, funded, and maintained correctly, when Dad dies, let's say the two kids as the successor trustees, if they want to sell the house, day after Dan dies, they plop a for sale sign in the yard, find a buyer, they sell the house, title's clear, it's in the trust, two kids can sell it, check payable to the trust, two kids handle that. Trust says everything in the trust goes 5% to each grandchild, 40% to each child. Two kids disperse it out that way. End of story. No lawyer, no court involvement. All right. Going back to just a couple of final chat things that are real important. HIPAA release. Yeah, all that's part of that healthcare power of attorney. Should we need to have? Yeah. Each spouse has their own set of those HIPAA releases, powers of attorney, advanced medical directive. They're called different things, but yes, couples don't do that jointly. Really, the only thing that they do jointly is set up a trust, one trust instrument, joint trust, husband and wife both sign it, but their wills, their powers of attorney, their advanced directives, their HIPAA releases, all those are, each spouse has, their own individual documents. Now, husband and wife will often appoint each other first as the one that they'd want making decisions for them if they were incapacitated, but each spouse has their own set of documents. All right, going from here, I know we have people on this because you've said from New York, from Arkansas. If you're from somewhere else, throw it in the chat room. I'd love to hear where people are from. But sometimes, and what we got coming up next, we got 3 more. You can go after this YouTube Live. I'm going to go on our channel's community tab and post the next 3 daily, 10 a.m. Central Time, different topics each day. Got some interesting ones coming up. Tomorrow's how to keep your heirs from fighting. The next day is how to do a handwritten will that doesn't need notary and witness requirements if you're cooped up in your home and you can't get out. And then the next one is how to choose between a will and a trust and what's right for you. Those are coming up over the next 3 days. But if you do live in Louisiana, and I'm sorry I can't help you. If you live in New York or Arkansas, I can help you just by providing you with this information, but I can't be your lawyer and I can't provide legal services to you. If you live in Louisiana, a lot of people, I think about a quarter of the people who are in my YouTube sphere are from Louisiana. If you want to just have a conversation, we've made it pretty easy for people to do that. You can go to our website, rabelaestateplanning.com, or go in the description to any of my 400 plus videos. You'll see a link that you can click, and then it takes you to my schedule. And you just schedule on your time. I've already blocked off when I'm available, just a 15-minute phone call where it'll be scheduled. I'll call you, you schedule it, you'll get the confirmation emails, I'll call you, I'll ask you, what do you want to make sure we talk about? It will just start a conversation, and where it goes from there is up to you. But a lot of people like that they can do that from their home. It doesn't cost anything to do that. And so again, if you want to explore that, you go to our website or one of the descriptions of in one of my videos, click the link that'll take you to my calendar, and you're off and running. Okay, so with that in mind, we're going to wrap it up. 40 minutes is about where I wanted to be today. I'll hang on for a second. Dallas, Texas. Okay, we got Texas, we got New York, we got Arkansas. It looks like we got some states starting to open up. I think Texas has opened up a little bit. Arkansas, I don't know what's going on there, but didn't seem like Arkansas was too bad a problem. New York, well, I guess it depends on what part of New York that you're from, but New York seems to be getting, the majority of the attention, just because New York City was really, hit hard. And now we got people from California. Fantastic. Thanks, Ines Elias from California. Great to have you on the YouTube Live. We will see you tomorrow, 10 a.m., same time. Check the community tab. Thanks so much for being on today. We'll see you tomorrow.